Welcome to third. I'm going to quit counting. Senate Judiciary hearing, thank you. There are two sign-up sheets up here for the two bills we're going to hear today. If you want to speak on either one of these bills, please come up here and sign up. We'll leave those out for another minute. That way we can make sure we call upon you. I will ask Senator Hatchett, if you'll please open us up in a word of prayer. What's your mic number?
Number
13. You're the one presenting the bill, so you can get warmed up.
Speak today.
There you go.
Let us pray. Dear Heavenly Father, thank you for this day, and thank you for the opportunity that you've given us to live in this country, to live in this state. Please continue to speak to us and through us as we represent your people and our constituents. In Jesus' name I pray. Amen.
Thank you for doing that. I'll tell you what, we will start with the second bill on the agenda, Senate Bill 60. If you want to come down here, Senator Hatchett. I believe Senator Jones is also here. Do you want to come down as well for Senate Bill 60? Okay, we'll see. The reason I ask, and you may want to reference this, I believe Senator Jones has another bill in the committee that was aiming to do the same thing, and he's working with Senator Hatchett on this version, letting you get all the credit for it and be the face of it. But behind the scenes working with you on this, I know he's here today supporting your efforts on this bill. So if you will first off, let's make sure we're all on the same bill. We have the original bill, LC 280558. Is that what you have?
Yes, Mr. Chairman.
All right, if you'll please present to us Senate Bill 60.
So as you mentioned, this bill is one that's very similar to a bill that Senator Jones...
Let me turn your mic on. All right, there you go.
Can you hear me? Okay. This bill is similar to a bill that Senator Jones has dropped, and it is a bipartisan bill. It's one that we heard last year as well. It got out of this committee, went to the floor, passed overwhelmingly, got to the House, and got held up on sine die. So I'm bringing it back this year. What it is this is basically a result of a collaboration and negotiation with metal theft stakeholders, which includes various business, telecom, utility, real estate, agricultural organizations, and more. Last year we had a group of about 30 different organizations that crafted this bill. What it does is right now in the state of Georgia, if you get there, well, first off, there's a huge catalytic converter theft problem. You see it a lot of times with churches. People are able to get up underneath a bus, a church bus, a vehicle with a Sawzall, cut off a catalytic converter, and get out in the matter of seconds. What this bill aims to do is to give law enforcement the tools that they need in order to, first off, stop someone that has a used attached catalytic converter and, be able to prosecute them. Right now, you can have 300 catalytic converters in the back of your truck, and a police officer can't do anything. So what this aims to do is give law enforcement officers the tools they need. I have worked since this bill passed the Senate last year with my local law enforcement and sheriff's office. We actually have a program right now to help deter these crimes by and we partnered with our technical school. We actually will lift a vehicle up, put fluorescent orange paint on the catalytic converter, and we can mark the catalytic converter with the last 8 digits of the VIN. And what that's used to do is to be a deterrent. If you get up underneath a vehicle and see bright orange paint and a VIN number, more than likely you're going to go to the next one. And so we've been able to do that with local government partners. We're trying to expand throughout the state, but this bill is an attempt to help a really big problem in the state. One thing that it does is it requires you to be a secondary metal recycler in the state of Georgia to have possession of a used detached catalytic converter if it's not your own. We're not trying to crack down on someone that, if my catalytic converters went bad and I removed them from my vehicle, went to AutoZone, I can legally do that because I have the registration to the vehicle that the catalytic converter came off of. If I buy a catalytic converter, as long as I have the receipt, then that's still lawful possession. But if I have 300 catalytic converters, that's when I can get into trouble. Beyond the catalytic converter piece, this is the second piece is a 2-year pilot program for metal recyclers to pay cash for scrap metal. One thing that I have seen in my district is I've toured these facilities, recycling facilities, and somebody can bring in, a truckload of scrap metal, and it may be worth $4. And what they'll have to do is the recycler will have to write out a check for $4, which costs the business money. And then if the person that brings the metal, if the person that brings in the metal doesn't have a bank account, which a lot of people, believe it or not, don't, they don't trust the government for some reason, they would have to go cash it. And it's just, what we're trying to do is allow them to just pay cash if it's under $100. This will be a 2-year program, and it's pretty self-explanatory. Once again, this got through the Senate pretty easily last year. The only difference between this bill this year and the bill that passed last year is at the request of the Sheriff's Association, there's some more regulation on who can actually become a registered secondary metal recycler. If you've been convicted of 3 felonies involving metal theft, for example, in the past 5 years, you will not be eligible. It's a good bill, and I'm happy to answer any questions.
In our folder is a proposed amendment. Can you please address that as well?
Yeah, Mr. Chairman, I apologize. I meant to do that earlier. What this does is there's a civil forfeiture provision in the bill. What this says is the amendment states that the forfeiture will not occur until after the conviction.
All right, any questions for Senator Hatchett? And I'm assuming you're asking if we move this bill that someone offer this amendment as well.
Yes, Mr. Chairman.
You have a question from Senator Sessler.
Thank you, Mr. Chairman. To the author, appreciate you bringing this, and appreciate the addition on, I guess it's section 1.6 that deals with registered agents and fingerprints and the being able to take them out of operation if they're under indictment. Could you speak to that a little bit more detail?
Which line are you referring to right now?
Looking at line 336 through 339 in particular.
Okay, so it's a secondary metal recycler's registered agent shall be ineligible to obtain a new registration if such person is under indictment for a felony offense or violation of this article. This article is Article 14. It deals with metal thefts specifically. And what the registered agent is it's not synonymous with the registered agent that you are familiar with the Secretary of State that you register with for service of process. What this is a registered agent with the sheriff's office in that county, and it's for the sheriff's office to have basically a point of contact with the secondary metal company or business. And if you've been indicted or have been convicted of metal theft, we don't think that's an appropriate person to communicate with the sheriff's office.
I get it. I guess and if there's other folks speaking to this, Mr. Chairman, I can raise it later. I just I love the fact that they've been convicted of a felony violation of this in the past 5 years. They can't register somewhere else. I mean, if they're convicted of anything related to this, I mean, a felony is not the first offense. If they're convicted of this, should they not have a violation? Should they not be prohibited from operating if they're offended one time? I think this requires them to be convicted 2 or 3 times to have a felony as a result of this code section. Is that not right?
Right. The violation of the code section, obviously, it's the 3rd offense that becomes a felony.
Yeah.
We're not trying to punish people for a mistake. What we're trying to do is if you have a pattern or propensity for metal theft, that you cannot be the registered agent for that business.
Oh, I'm with you. I was just, my thinking was, would you, if felony requires a 3rd an actual conviction, would you be open to a 2nd or subsequent conviction prohibiting you? So you get 1 strike, you can still be in business, but you get 2 convictions under this code section, then you'd be prohibited from registering. I'm just concerned about cleaning up bad actors, but it's just a thought. As I was reading this, I wasn't sure if you would be open to that.
Yeah. Right now, I'm obviously, would be, if you'd like to propose an amendment, this has been a very in-depth dive, and we've had coordination with sheriff's offices. This is the language that we've all come to agree on, and I'd prefer that it stay the same right now.
All right, you have no other questions from the committee. You're welcome to sit tight if you want. There's 4 people that signed up to speak on the bill. I'll say they're for the bill. So if you think you're winning, don't kill it by talking too much. First is Brian Hudson with Georgia Recyclers Association, if I can say that. I like how you're walking so slowly up here too.
I can speed up.
Yeah, thank you.
And Brian, I think we're winning, so.
Yeah. Hey, how you doing?
We'll see soon. Calzer hadn't said anything. You never know.
I better hurry up. Mr. Chairman, members of the committee, thank you so much for having me. Again, my name is Brian Hudson. I represent the Georgia Recyclers Association. I think Senator Hatchett obviously did a great job of presenting the bill, and we have worked tirelessly with a lot of folks in the hallway in the different industries, as well as Terry Norris and Mike Mitchell with the Sheriff's Department to come up with this legislation. So we speak in favor of the bill. I'm happy to take any questions.
Appreciate your work, especially in advance. There's a lot of people don't see all the work you guys did in advance on this bill to make this something that everybody is comfortable with. Any questions for Mr. Hudson? All right. Is Sam Bacon also going to speak from the organization?
Sam is here. Sam is actually the president of the Georgia Recyclers Association. He's also a secondary metals recycler. He can speak if you want, Mr. Chairman, but he can answer any specific questions as it relates to the industry if you like.
Okay. Unless anybody has any particular questions. All right. Thank you.
Thank you.
All right. We have Derek Corbett from Pull Apart. Good afternoon, Mr. Corbett.
Thank you, sir.
Good to see you again.
Good to be here. Thank you. My name is Derek Corbett. I'm with Pull Apart. We're the largest privately owned used auto recycler in the country. This bill is fantastic. We're excited about it. I appreciate Senator Hatch's hard work. It represents a collaboration between the recycling industry and the Sheriff's Association, an effort to give them the tools to reduce crime and give recyclers the tools to be successful. So I'm excited to answer any questions, but thankful to the committee for taking it up, thankful to the senator for pushing it forward. Thank you.
All right. You do have a question from Senator Calzer.
Yes, sir.
Thank you, Mr. Chairman. So I'm interested, this was a battle around this place for several years until we finally settled a few years ago. At the time, there was a big problem with the copper theft, if I remember, and of course these catalytic converters. Has that subsided some? Did we help quell that with the last bill we passed or not?
You have. The answer is absolutely. Georgia metal theft laws are really the foundation for a lot of the legislation you find in all 50 states that we do business, and it's because it was effective. And what you see now is a lot less metal theft. Catalytic converters are on the rise. That's the new fad, but you see a lot less metal theft. And in fact, this component of the bill wouldn't be here if it wasn't for the industry and the senator bringing together all those stakeholders from the telecom industry and the other railroads and the other affected industries, and getting buy-in from them saying, okay, we're satisfied that the work that was done a decade ago has proven successful, and with the restrictions that are currently in the law, the proposed legislation, they're comfortable, and it is a reflection of the hard work that was done prior.
So this seems to have a little bit of loosening now that you're going to allow cash purchases, which was the reason we prohibited those, was to make it more difficult to fence the stolen metals.
That's right.
But you're putting more teeth on it if somebody's hauling a backseat full of catalytic converters. They've stolen them.
Well, that's right. Big problem, a big void in the law today that hurts our sheriff's deputies is you pull a car over with 300 catalytic converters. It's impossible to tie it to a vehicle. It's impossible to show that it's stolen, and so they're helpless, though they know that it's a nefarious action that's taken place. So in the legislation, we maintain the prohibitions for cash purchases on telecom, wire, copper, and catalytic converters, those high-value metals. but we empower our small mom and pop businesses to be able to stop issuing $7 checks, which are very cumbersome.
Thank you.
All right, you have no other questions? You actually do. Senator Rett.
Thank you, Mr. Chairman. Pull apart.
Yes,
Is
sir.
that where you go and you take the parts off that you need for your? Or
Well,
am I mixing
I
it
was
up?
told to be short, but now you're starting to speak to my heart here, and that is
This
the
is
right
not
answer.
a time for a commercial.
We buy hundreds of thousands of cars a year all over the country, end-of-life vehicles. We bring them in, and the first thing we do is depollute these vehicles. We get all the mercury, oil, gas, all the filthy things that are going to hurt the environment. We get them out, and we recycle all of that. Then we set these cars on our display yard, and when I say display yard, I mean a 20-acre facility with 7,000 to 8,000 vehicles. And you can come in and you can buy the part or piece that you
Take apart.
desire. And just
Right.
like pulling the rags out of the rubbish heap, we're putting those usable pieces back into the circular economy, extending their life, reducing waste. And then what's not bought, what's not in high demand, we bring it back in, we rip it all out. We send our hulks, our auto body hulks, to our shredders. We chop our own wire. We recycle our own aluminum. And then we put all that feedstock back into the supply chain so that it can become the next big thing.
Yeah, I have some good memories when I was a young man driving used vehicles. I had to go there and pull a part off for keep my truck running. I still go there now every now and then for some of my bills. I pull something apart and try and get them amended.
You tell me when you're going. We'll go together.
It just brought back some good memories when I saw that. Appreciate it.
I'm glad to hear that. Thank you.
And-
All right.
Mr. Chairman, if someone on the committee would also, there's one minor change as well that was brought to my attention before the meeting on line 52. It says Georgia Sheriff's Department. It would be more accurate to say Georgia Sheriff's Office, if somebody could offer that for me.
And the word sheriff and office, either one's capitalized, right?
Correct.
Okay. All right. You have no other questions? Thank you, Mr. Corbett. Appreciate you. We have one other person signed up to speak, Mr. Eric, is it Campos, with National Insurance Crime Bureau. Good afternoon.
Thank you, Mr. Chair. I will be brief. My name is Eric DeCampos. I represent the National Insurance Crime Bureau. We are in support of SB 60. Its provisions will help combat catalytic converter thefts. Just a quick statistic. Since 2019, catalytic converter thefts have risen across the country by 1,200%. Here in the state of Georgia, for that same period of time, they've risen by 1,000%. The provisions in these bills will help deter these crimes, will provide law enforcement and regulators with the tools that they need to investigate these thefts, put an end to prolific thieves, organized criminal rings, and anyone else who decides to rip off one of these catalytic converters from your vehicles. Thank you very much, and I'm happy to answer any questions.
All right. Thank you, Mr. DeCampos. Any questions for him? All right. Thank you. There's nobody else that signed up to speak on the bill. Anything else you want to add on this one?
No, Mr. Chairman, just ask for favorable consideration of the bill with the amendments.
So we have two proposed amendments. Let's first see if we have a motion from the committee. We have a motion to pass Senate Bill 60 LC 280558 by Senator Setzler. We have a second. Second by Senator Kennedy. We have two amendments the author mentions. Anybody want to first offer the amendment, which is AM 281889? It's offered by Senator Kennedy. And are we good, Paul, with the way this is drafted, as soon as an amendment as I'm doing? Okay. We have a second from Senator Setzler. Any discussion? All those in favor of the amendment, please say aye.
Aye.
Any opposed? All right, passed unanimously. Second noted amendment would be on line 52 of the bill, changing the word department to office. Is that right?
Yes, Mr. Chairman.
Does someone want to offer that amendment? Senator Setzler makes the motion. Is there a second?
Second.
Second by Senator Parent. Any discussion? All those in favor, please say aye. That carries. And back to the underlying motion. Any other amendments? Bat the airline motion do pass now as amended. All those in favor, please raise your hand. It is unanimous. All right. So now we will shift gears to Senate Bill 44. And I believe you're working off a substitute on this one.
Yes, Mr. Chairman.
We have LC 480816. Is that correct?
Yes, that's correct.
All right. If you will please present Senate Bill 44.
So today I'm bringing before you the substitute to Senate Bill 44. We're going off of the, obviously, LC 480816 ECS. I'm bringing this on behalf of the governor. Governor Kemp has made tackling criminal street gangs a priority since the beginning of his administration. Through listening to local law enforcement and prosecutors and with the help from the legislature, the governor has championed one of the strongest criminal gang statutes in the country. He created the Gang Task Force at the GBI and added the Gang Prosecution Unit to the Attorney General's office. And I have someone from the Attorney General's office here today to help answer any questions you may have. Building on his promises, the governor, in partnering with the AG's office, the lieutenant governor, he's seeking to continue to crack down on criminal street gangs by giving prosecutors the tools to go after known gang members and protect children in our state. Part 1 of this bill seeks to add mandatory minimum sentence of 5 years for those in violation of the criminal street gang statute in order to crack down on individuals that perpetrate these crimes. The bill provides district attorneys, the attorney general, and judges with tools that will help infiltrate these criminal organizations and bring more gang members to justice. Part 2 of this bill adds enhanced penalties on gang members that recruit children into their criminal enterprise. The governor's office has been informed of the rising occurrence of gang members targeting children for criminal street gang recruitment. This past November, the governor and the attorney general announced an indictment of 17 alleged gang members in which, among other crimes, gang members were recruiting young children by using family-friendly events. While all efforts to combat criminal street gang activities have had a tremendous impact throughout the state of Georgia, more must be done to keep our children away from a life of crime and keep our community safe. Through this bill, the governor's office wants to send a strong message to gang members. You come after our children and endanger our communities, and we will come after you. One of the, I guess, the big reasons behind this bill, and I've learned, and I've been working with the AG's office, with the lieutenant governor, with district attorneys, one of whom is here today, an assistant district attorney that's going to be testifying. These criminal organizations, gangs, they are in the business of making money. And the lifeblood of their organization is recruitment. There is a strong movement, and they are quoted in something that the Attorney General's office will speak to in just a minute. There's what they are calling a youth movement. They are trying to recruit younger people, and the reasons why is, number one, they're not as obvious of a target for law enforcement officers. They can carry out the missions of the gang, and their penalties will be less. So you can send a 14-year-old kid, to go rob several cars or carry drugs on their person, and they'll be out in a couple days. Whereas if they're older, they'll stay in longer. And mandatory minimums are obviously a sensitive subject, especially in this committee. I'm not always for mandatory minimums, but in this case, you're talking about a group of individuals that are targeting children and trying to recruit them into a criminal enterprise. And you're taking away their innocence, you're taking away their chance at life, and not only that, you're taking them away from their parents. And that, in my opinion, is something that is worthy of a mandatory minimum here. If you recruit a child into a gang and you're convicted, a 10-year mandatory minimum in my mind is very proper. Mr. Chairman, I'm happy to answer any questions, and I have several witnesses here today that can also help.
Do we have any questions at this time for the author? You do have some questions. Senator Jones?
Thank you, Mr. Chair. I'm going to page 4. And I'm just looking at lines 86 through 89 and just wondering how that works as a practical matter. So we have from lines 75 through 85, it details when the judge can deviate from the mandatory minimums. But then it comes back and says if he departs, then he has to say why he's departing. Is that just a restatement of 75 through 84, or it's additional reasons?
Refer to Kara. Yeah.
Sure. So I think the factors that are outlined in these, the earlier lines in the 70s, detail what the judge needs to find in order to sort of check the box and deviate from that recommendation. And then they need to publicly state on the record their findings on those, so that we know why they feel that those special provisions were satisfied in this case, why this particular defendant checks all the boxes necessary to meet what's required to deviate in that case.
You want to introduce yourself to the committee, if you will?
Yes, good afternoon. My
Senator
name is
Hatch didn't
Kara
do that.
Convery. No
Sorry.
problem. Kara Convery. I'm the section chief of the new gang unit at the Attorney General's office. I work with a team of prosecutors and investigators prosecuting gang cases all over the state.
Okay, thank you. Yeah, I had one other question, which goes to when it says on line 87, 88, and it says about the judge shall specify on the record the circumstances for the reduction and the interest served by such departure. Is that different than line 84 when it says that he's supposed to state that the interest of justice would not be served by the imposition of the mandatory minimum sentence? Is it the same? I'm just curious how
Yes,
it
sir.
reads.
Yeah, no,
Okay.
it's not different. Essentially, B is that the court needs to publicly state the way that they found each of those previously mentioned provisions were satisfied.
Any other questions from the committee for the author? All right, we have several people signed to speak. I think we'll let, you either come back to your seat or sit in the front row there. We'll start with Director Melvin of the GBI.
Thank you, sir.
Good afternoon.
Good afternoon, Senator. It's good to see you. I'm John Melvin. I'm the Executive Director of the Georgia Bureau of Investigations. I come at it with and ask for a favorable consideration of this bill from two perspectives. One is as Executive Director of the GBI. The other perspective is I was 25 years as a prosecutor fighting these various cases, bringing RICO and gang charges, and taking out hundreds of defendants. I can tell you that for 2022, the Georgia Bureau of Investigations made 363 gang arrests. We had 396 gang nexus, and we are only touching the tip of the iceberg. What I've seen with the 4 years that I've been with the Bureau is a logarithmic increase in the number of gang cases that the Bureau is working and the gang problem statewide. We humbly beseech you to strongly consider the mandatory minimums that are in place here so that we can tighten it up while at the same time giving the keys and empowering the defendants to be able to assist the state in getting rid of this pernicious problem. One of the most chilling things that happened to me as a prosecutor over 25 years, and I handled death penalty cases, is that I was standing in court when a Bloods member testified under oath. We have gang members in every high school, every middle school, every elementary school in this county. My experience showed that was true. And I sincerely appreciate the efforts of Senator Hatchett and the favorable consideration of this committee in order to address that problem, because I do know that the governor is not only interested in punishing those that are committing gang crimes, but also shutting off the flow of gang members into that community. And I think that this provision accomplishes that, and we would ask for your favorable consideration.
All right, thank you, Mr. Melvin. Any questions for him from the committee? Senator Setzler.
Hey, Mr. Chair. Director, thanks for being here. Help me understand structurally how we're changing this. I mean, it looks like the stricken language talks about minimum sentences. Is the issue that there's no strict mandatory minimum that prohibits anything from being probated or otherwise? And what other elements of this, other than mandatory minimum in the bill, that are helpful to a prosecutor to really get at the heart of what you're talking about?
And really, Senator, every provision in this bill was helpful. So in subsection K1, that's going to be replacing K, well, we have the definitional sections. Then we come to K2. Currently, if I'm a gang member and I go before the court, the sentence is 5 to 20, which all can be probated. As a matter of fact, there's been high-profile cases where we've had probation recently. That's changed to make it mandatory minimum of 5 all the way up to 20 and consecutive to any sentence imposed. Then we go down to subsection 3A, and this is the provision because under the gang statute, you can be punished for committing the gang crime, for doing it to increase your status, to do it to get proceeds, to do it if you're a leader. Every one of those has specific provisions, as well as various threat provisions. What 3A does is it says, okay, here, if you recruit a child that's less than 17 years old or someone who is mentally disabled, we're going to kick it up, not 5, we're going to kick it up to 10 as mandatory minimum. Then if you do it again, it's 15 to 25. Then we move down to subsection 3B, which says, and there's not going to be any reduction in this. Subsection 4 really is the one that gives the keys to the kingdom for a defendant to help us as a state to be able to go out there and say, all right, you want out from under these mandatory minimums? Then you help the DA. Talk to us in chambers if necessary in order to help us be able to take out the rest of the gang. And then perhaps you're in a jurisdiction where maybe the district attorney is not as friendly in that situation. Then you have subsection 5 that says, okay, the court even has the discretion to do it. But if the court does it, not at the DA's request, then they're going to have to find the 5 specific provisions that are listed here. They're going to have to announce it on the record so that there's a record of it, and then it's going to be appealable and directly appealable. And that's the provisions of this statute.
So these elements here are appealable, and if a court of appeals looks at this and thinks these are not substantially met, then
it'll be kicked back for appropriate sentencing, sir.
Gotcha. Okay. Yes, sir. Thank you, sir.
Yes, sir.
That 2 questions I had on the appeal. Do you know what the standard review is for that appeal? What the court be looking at? Is it abuse of discretion, or do we know? Is that what
I'm
it is?
going to have to defer to the AG's office.
Okay,
on that
there's
one.
other
Yes,
people
sir.
that's
I
not to
appreciate it.
speak.
Yes, sir.
The other question I had, section 4, you mentioned about someone that decides to cooperate.
Yes, sir.
Would that apply to cases involving minors as well? That would also apply to a case under 3A as well?
Yes, sir. There's no limitation upon it. It
Okay.
says the DA can move.
Okay.
Yes, sir.
Any other questions? Senator, which mic number are you? 13?
13.
Okay.
It would not apply to the recruitment of minors. That's right.
Section 4 would not?
It would not. Just the street gang violations for the mandatory minimum 5, but the mandatory minimums with the recruitment of minors, that would not apply.
And I apologize, Senator. I misheard your question.
Okay.
Be departed from for this part.
Yep. That's on line 60,
Right.
65, as Senator Parent was showing me. Okay.
Yes, sir.
Any other questions from the committee? All right. Thank you.
Thank you, Senator. Thank you, sir.
Next, we have Maisie Lynn Girton with Georgia Association of Criminal Defense Lawyers. I believe you also have your Lawyer of the Week as well. I'm sure you'll introduce her to us.
I will. Thank you. Thanks for having us. Good to
Thank
see you,
you.
Chairman, and the rest of the committee. I'm joined today by Noe Siki. She is a criminal defense practitioner out of Macon, Georgia. Sorry I didn't get up to introduce you personally before the meeting, Senator Kennedy. And I will let Noe start us off today.
Thank you, Maisie Lynn. I want to start by just saying thank you to Mr. Chairman and the committee for your time today and for your attention to this. I am, as Maisie Lynn stated, a criminal defense practitioner. I'm in private practice in Macon, Georgia. I was previously with the Public Defender's Office in that area as well. And as a practitioner, I spend a lot of time in Chapter 16 dealing with these issues. My concerns going to focus largely on Part 2. Currently, under Georgia law, there are avenues to deal with the prosecution of individuals recruiting minors or others for gang participation. OCGA section 1615.4 subsection K4 provides penalties for recruiting minors or for recruiting people in general. As stated, it does provide that the penalty imposed is an imprisonment from 5 to 20 years, which allows judicial discretion. Unlike other sections of that statute, it does not allow for the option of simply paying fines as a bypass. It is a stricter section. Depending on the facts of the case, the judge can decide under current law whether 5 years imprisonment is necessary without taking away that discernment. With these changes, however, I would argue that the judge's hands would be tied. As was stated, lines 78 through 85 do provide for a carve-out. However, where that mandatory minimum doesn't have to be imposed, but it does create more of a sense of trepidation that sentencing will be appealed, as that appellate language is present, which we don't see hardly anywhere else within the criminal code. Finally, the main thing that I would want to say is that, again, in practice and in effect, this bill will not stop individuals from preying on young, vulnerable children. Instead, it seems that it will disproportionately harm teenagers and harm siblings, where an older brother who is a member of a gang, because oftentimes people join coming from unstable homes or economic instability or even low education. We see those as being contributing factors, where they have a younger sibling to join in with them. Now 14, 15, 16-year-olds are looking at mandatory 5 and 10-year sentences for this activity. This, as was stated earlier, the exceptions that were mentioned don't apply to recruiting, to those who recruit minors, so those would have to be imposed. And it's my position that this will just create a further disproportionate harm in certain communities.
Yeah, I would just start where Ms. Siki's ended, just to say that this idea that somehow there's a win-win situation for people who are accused of recruiting and the state in solving these cases is just not true about this legislation. And if we want to talk more about that, I'd be happy to, but I don't want to belabor the point either. And I also just wanted to give you an example of where we are today on sentencing under this statute. If someone was charged with one kind of a criminal gang activity predicated on a theft of something that was valued around $6,000, and also RICO was tacked on, which is one of the tools that the prosecutors do have in prosecuting gang cases, and we routinely see it, that now a RICO charge is combined with a gang charge on most every indictment. That's a 40-year exposure with just a theft of something of $6,000 coupled with the gang and RICO charges. I mean, there's a case being prosecuted just down the street right now, the YSL gang case, where if you look through that indictment, there's not this exact example that I'm giving you, but you will see that each individual person is being charged individually for whatever particular underlying act, along with, in some cases, a gang charge, and in, I believe, every defendant's case, a RICO charge. Mm-hmm. So we're not starting from a place of low sentencing schemes in the gang crime statutory scheme. Our organization also does want to talk to you more about what's happening in this bill. And in the substitute, it starts at line 86 and goes through the end of that section 2 at line 99. This is where the bill would give the prosecutors an ability to appeal a judge's discretionary decision to downward depart from one of these mandatory minimum sentences. DAs have the power to appeal in our state in very limited situations under our law. Giving them another opportunity here is basically a second bite at the apple, if you will. And it cuts against our systems of reliance on finality, which, and doing that, they're doing it without advancing individual liberty. So when someone that's accused of a crime has a right to appeal, it typically is because of some kind of liberty or constitutional interest. That's not the case for the state. That's not the case for the government. It's just being handed to them here after having successfully, mind you, successfully prosecuted and secured a sentence, and now is getting to appeal that sentence. It is our request that you dial that back. There's no need to have the prosecution appealing the court's decisions on these sentencing matters. In addition, this appellate right is going to be needlessly burdensome on an already overwrought criminal legal system, taxing not only the prosecutors bringing the appeal, but the defense, which in this case in our state is far more likely to be on the executive's dime, because the majority of our prosecutions are defended by the men and women who make up the Georgia Public Defender Council, the vast majority. So the appellate courts, in addition to the clerks, and if the person's being held in custody, I would even argue the counties are going to be bearing additional costs because of this additional appellate right that we see precious little of in the rest of our code. To achieve our request there, you would just simply have to strike lines 86 through 99. Enhanced penalties are simply not the answer. I mean, I started by telling you about the 40 years you could easily be exposed to with a theft, gang, and RICO charge. The United States has the highest incarceration rates in the world. Every time a mandatory minimum bill comes before you, I come before you and tell you all of these statistics that remain true. Georgia's rate of incarceration per capita as of September of 2021 was the 4th highest in the world if you were to treat us per capita like another country. When you look at an analysis of incarceration and crime rates, you see that high incarceration rates are not a rational response to high crime rates, but they are a politically expedient response to fear. Mandatory minimums don't deter crime. We know the research is clear that people in reality don't look to see what the criminal code says, find the mandatory penalty, and become discouraged by that penalty to pursue whatever behavior they're going to pursue. And I mean, honestly, even just looking up some of this stuff for you guys today, it's a complicated code section. Figuring out these sentencing schemes is it's also difficult. It's not a deterrent to know what the crimes punishments are. What we know is that the clear idea that someone will be caught and punished quickly is what deter crimes. And in fact, a shorter sentence is going to potentially be more deterrent, because the longer someone stays in custody, the more likely they are to become caught in a recidivist cycle of criminal legal system involvement. Our main ask about this bill is the 86 through 99 removal, but also to dial back the mandatory minimums, believing that the exposure someone faces right now on these charges in our state is more than sufficient. And if you have any questions, I'd be glad to answer them for you.
Do you know when else in the code a prosecutor can appeal? You mentioned it happens rarely. What are the other circumstances you're aware of?
There's one that is tied to 1710.6.2, and I will let Robert correct me if I'm wrong about that, but this, in the sex offender sentencing scheme, both parties have an appellate right there. It's codified in the code section's in your bill, 571, captures the opportunities that the state has to appeal. And that most of them are things like, decisions on orders, evidentiary matters. I mean, the only, and I, again, would stand corrected, but the only sentencing appellate right I saw was that sex offender one.
Okay. Yeah, more questions from the committee. Senator Calzert.
Thank you, Mr. Chairman. I don't know if you were here the other day. The chairman asked a great question to a presenter. If this doesn't help, what do you suggest? I mean, we are dealing with proliferation of gang activity, recruitment of young kids And what other tools do we have other than to get these people off the street if they're doing it? I mean, we've tried the rehabilitation route, we've tried the 3 strikes you're out, we've tried harsher penalties. If you were up here, what would you do to solve this problem? Or help?
Yeah.
I don't think you can wave your magic
If I were up
wand.
there, I would be talking to my colleagues on the Education Committee, to my colleagues on, I don't know if you guys have multiple health committees this year now. The issues that bring us here, in my view, personally, this is just me talking, not necessarily Gachtel's position, but the children that are being recruited, the families that are engaged in this, they're not there because they want to be involved in the criminal legal system. It's what Ms. Siki was alluding to when she was speaking earlier. It's a lack of advantage in any number of fronts: housing, education, access to employment. I just don't believe that carceral measures are going to be the answer to any of this. Like you've said, we've already done some of this. We've done 3 strikes. We've done these things. The money is not being spent on the collateral consequences or the collateral matters that draw a child into a place where they find identity and camaraderie. And it's broken and it's backward, but that's what they're finding there. Years ago, I'm sorry I'm not going to be able to call his name, but there was a general, one of the highest ranking generals in the Marine Corps was discussing how the young men at that time that he was seeing come in, and it was men he was discussing in this particular conversation, were just the boundaries that the military he saw giving them were somehow comforting. And I think the same thing can happen here, right? When you enter into a community of people, whether it's a fraternity on a college campus, or, I mean, even my daughter's elementary school student government, when you find a place of belonging, you dig in and get comfortable there. And unfortunately, a lot of our children are finding that in gangs. We're not offering them much else. And I would love to talk more about that when we're not here. And I'm sure a lot of my colleagues in the audience who work in these spaces of education and housing and employment would have a lot more robust and thoughtful, insightful responses for you.
Senator Watson.
Thank you, Mr. Chairman. You know, I get it, the education and housing and let me throw in mental health issues too. But you know, when, in the back of my mind, you know, mental health, you know, whether you know bipolar, schizophrenia, or personality disorders, but is the thing that you said that this is not the answer to any of this, and you know. In my experience in treating patients, the ones who are sociopaths, not really curable. And I think that's what this is really getting at, is because you're correct. It's not going to be a deterrent for a sociopath, right? I mean, that's I don't really, that's a rhetorical question, because you know the answer to that, and I think everybody in the room knows the answer to that. But so what do you really want to do for a person who has a sociopathy? You got to get them out of, you got to get them away from people who are that make you, you know, afraid, vulnerable. I mean, that's the difficult part of this. So you're correct, absolutely. Except you're making the place, or you're making place safe, because recruiting a recruiting a person who's young, a person who is vulnerable, that's just not right. And I would challenge you to say that maybe the sociopath is the reason we're doing this. But I get the other aspects of that, and that's probably a small piece of the puzzle, or is it maybe a big piece of the puzzle? But the underlying thing that I think that we're getting at is a little different than what you're describing. I'm sorry if that was not a question, maybe, or was it? I apologize.
And I can't speak to the mental health aspect of what you're
Isn't that
saying,
true?
Senator.
Isn't that true?
Or we can just move on and pretend it's a statement.
What we do see, though, is we know that in our system, 17-year-olds are adults. And so when we talk about this idea of recruiting, I think the mental image that probably comes to your mind is a 27, 37, 42-year-old adult person recruiting a child. And while that may happen, and I don't know all the exact details, what I know is what Ms. Siki sees in her practice, and she talked about earlier. We know that this recruiting that's going to be prosecuted is going to include a 17-year-old adult who recruits their 14-year-old little brother. That's who's going to be prosecuted under this bill. The 19-year-old who recruits their 17-year-old or 16-year-old or 15-year-old. This is going to be young people recruiting young people, and we're going to talk about it like it's a bunch of adults behaving badly, but every one of those people is under 25 years old, and we've talked about the brain science before, you and I, Dr. Watson. They are not using a fully developed brain, and they are going to be these young offenders, these youthful offenders up to 25 years old, are going to be part of who are going to get prosecuted as recruiters. And we're going to think of them as predators, but really they're just children themselves.
And that goes to the discretion of the judge.
It should, but with mandatory minimum sentences, that is removed.
He would just be required to list that as one of the reasons, right?
No,
No.
not under this. There's not that exception.
I
So-
didn't say
Not for
it was that was listed as the exception.
Oh,
Maybe I
sorry.
did. Maybe I implied that. I apologize if I did. But wouldn't that fit under that category, or could it? Maybe the prosecutors would not.
The recruiting aspect is not.
Oh, I'm sorry. The recruiting does not have those
Right, the escape
exceptions. You're
route
right.
doesn't apply to the
I
recruiting.
stand corrected on that. You're
That's
correct.
Senator Jones?
Thank you, Mr. Chair. Just a couple of questions. Number one, on line 78 through 85, when it talks about the things the judge is going to take into consideration
Yes.
to depart, wouldn't these be things that he or she would take into consideration anyway when making a sentence without actually listing it? When you're having a sentencing and you're going through your sentencing, these are things that the judge would probably take into consideration in any event.
Absolutely. And
But-
this is a rubric that we see, and this is already in the code in other sections, so they've got some practice with it.
But then the difference would be that now that can be appealed once he or she makes this decision, because you're saying that now can be appealed.
In this case, yes.
And you think that could cause any kind of chilling type of effect to even try to put this down?
Well, you raise a good point. I think it would potentially also.
Another
Chill.
issue, and I had 3, so my number 2 is line 68 and 69,
Yes.
which basically deals with telling on somebody.
Yes.
So my question with that is, persons who are like the lower level offenders, they may not really have that. They're still going to get their mandatory minimum, but is it not accurate that they may not really even have that much information? So they sit in jail, but maybe somebody who's really more culpable, they can come and tell, but they might actually get out. Can that happen?
I can just say that I would not want to be the person in the prosecutor's office who has to divine whether or not the information that I'm getting is legitimate and reliable when someone is basically being, it's a carrot towards some kind of exception or freedom. I wouldn't want to be the one making the decision about the veracity of those statements.
And then my third one, I'll couch as one of those, isn't it true? Because it's more rhetorical, but my question is this. This really isn't new in the sense that we, all of us, Democrats, Republicans, say we know there's core issues out there that cause some of these problems, whether mental health, poverty, whatever it is. But we can't deal with those right now. We've got to deal with what we got right now. Put them in jail. 10 years later, same problems. And we say, and in fact, current President Biden gave a speech saying, I know there's problems, but we got to deal with it right now. We got to put them in jail. 10 years later, nothing's changed. We know there's core problems, but we can't deal with it right now. We got to put them in jail. When do we stop this kind of like just going in circles with this crime issue?
I wish I had the answer to that. If I did, I'd write a book, and I would be very wealthy and not sitting here trying to convince you not to prosecute people in this draconian and unnecessary way.
Senator Sessler?
Thank you, Mr. Chairman. I'm going to ask some questions, I guess, on both sides of this issue. I have a concern that if we don't have some kind of mandatory minimum structure, that you're not going to have equal justice across different judicial circuits. Like one may be giving people probated time, and other cases are getting hammered. So I do think the value of mandatory minimums, whatever the years would be, does create a level of uniformity. Because I do have concerns there's not uniformity across the state.
Well, you only get that uniformity that you're describing when you assume that everything leading up to that sentencing decision was equitable and uniform, and it's not. You're basically just pushing back in time in the process who gets to have that discretion and where the lack of uniformity is going to come in, and it's going to come in at the charging decision. It's going to either come in at the time of arrest, and it's going to be the discretion of the officers and investigators involved, or the inequities are going to get built in by the prosecutor who makes the charging decision. The only way that the mandatory minimums achieve what you're describing is when everything else is equal leading up to the sentencing moment. Otherwise, the person who was charged with with something lesser than the gang act isn't a part of your cohort of people being handled equitably. Does that make sense?
It does. I mean, but I think over time, particularly, you have organizations as sophisticated as gangs. They understand kind of what deals are being, what sentences are being given down for A and B and C. And I think over time they get wise about, okay, there's a mandatory minimum. This is going to happen. Versus in some jurisdictions, I think they would know in Macon what a sentencing framework is going to look like, in Fulton what a sentencing framework is going to look like, and in the Conasauga Judicial Circuit what that sentencing framework might look like, and those would not all align. So I mean, I would say the mandatory minimum framework, I think there's a justice component to it in as much as there's uniformity. My concern is just around the 5 to 20 minimum nature. Is 5 to 20 the right number? And to me, it comes down to what's the right number. And when you look at it, I looked up, and maybe I'm missing it. I'm looking at Title 16. When you look at criminal solicitation and conspiracy to commit a crime, conspiracy. I mean, when you look at the elements in lines 15 and 16, directly or through another acting upon such person's direction. So essentially, you have a principal, if you will, that's working through somebody else to recruit somebody. I mean, to me, that has the feel of sort of almost a conspiracy that's going on. You're working together in a team to do something. That criminal solicitation or criminal conspiracy to commit murder is a 1 to 10 in our code. So when you think about a murder case versus recruiting a gang case, I mean, I want to shut the gangs down, and I want there to be uniformity across our state in this. But as we think about this and we balance this out, how does it weigh with other things that are in our code? And I want there to be some proportionality. Maybe the other part of the code's wrong, and maybe I'm missing something. But I just was looking through this here. So I wanted to have that as background to ask the question, are the elements, so my real question, our first one, 15 and 16, directly or through another acting upon such person's direction, are those elements that could get someone subject to a pretty high mandatory minimum treatment here?
Well, I think
if I were acting through another person's actions to recruit somebody, does that get me into this mandatory minimum circumstance? Not an action of my own, but giving direction to somebody who then's going to act on somebody else. Am I reading lines 15 through 16 correctly?
I'm reading it similarly, but I also read this as a little bit of belt and suspenders to what our party to a crime concept already offers us under the law. I mean, this is probably one of those, Pete and Jill and Robert and I could sit and opine over this for a while together, but I don't know that this language is necessarily doing anything you can't do today under party to a crime, because a party to a crime is someone who participates or potentially acts
So my reading of criminal conspiracy is off. I'm misreading that.
I'm not sure that you're misreading it. I think these things are all. I guess I don't think that one of them makes the other one disappear. I think these are all ways to capture multiple people behaving in concert together.
Okay, so you're saying our current framework, if we're honest, allows somebody to be to get the full punishment of a crime, even if they're involved in an enterprise to do it.
Oh, absolutely, it does. No, without question.
All right, no other questions from the committee. Thank you all.
Thank you.
Next on the list is James Woodall, Southern Center for Human Rights. Good afternoon, Mr. Woodall. Well, good evening, almost, after 5 o'clock.
Good evening, good evening. James Woodall from the Southern Center for Human Rights. Thank you to the chair and the committee for consideration of this bill. And also, I'll also preface by saying, Senator Hatch, we want to come see you before we speak to a bill. We'd like to at least speak with the sponsor first. And we recognize, you know, where we are today as a state. The governor has said that this is a priority of his, as well as really a lot of Georgians, right? When we talk about public safety, we're all concerned about what our communities are experiencing each and every day all throughout this state. But I want to take a step back first and really review how we got here, because I know there was some conversation about, well, if this doesn't work, then what will? In 1992, and for context, I was born in 94. So this conversation has been going on since I've been alive, and we're still here to this day. But in 1992, the Georgia Street Gang Terrorism Prevention Act was codified, and in 1998, it was amended to focus on the gang activity and not just membership. So the activity that's being committed was focused on at that time. In 2006, it was amended to eliminate the requirement of establishing a pattern of activity to prove that violation. And at that time, the enhancement of penalties was enacted. In 2010, we expanded what evidence may be used to establish the existence of a street gang. In 2016, we increased the penalties for unlawful activities connected with this particular activity and provided for the mandatory minimums. And then in 2019, we included sex crimes into that defined activity. And so here we are again in 2023, talking again about mandatory minimums. Does this work? And what we know is that prosecution and incarceration does not decrease gang activity. In fact, if you send someone to prison, they're likely to continue gang activity. And so that is a reality that we've heard time and time again. In fact, we've had issues where gangs were sending hits to people that worked at these facilities. We've seen state law enforcement corrections officers murdered by people who have been convicted under these crimes. And so we have to be honest about what it is that the tools that we have provided to us and how effective they are for us to be able to achieve the common goals that we're looking at. But if we're looking at this specific legislation, as we've already heard, there's already existing law that targets recruitment activity. And I want to be very clear that is, again, similar to what Maisie Lynn shared, this is not just adults. We have people as young as, I don't want to go as low as 9 and 10, but they could technically be prosecuted under this legislation for recruiting another person who they are familiar with into a gang. I've seen it happen with my own eyes, communities that I've lived in. And so it is not arbitrary to believe that that can happen. And in fact, it already does. But the current law under the criminal gang, street gang activity code section prohibits causing, encouraging, soliciting, recruiting, or coercing another to participate in gang activity. And in addition to the overbroad definition of what a criminal street gang actually is, this specifically creates protections for those two categories of people that may be unintentionally harmed by this legislation itself. The current sentencing scheme already exists, 5 to 20 years. That is consecutive. So, Senator Sessler, what you raised about the 5 to 20-year scheme, this would be consecutive to whatever imposed sentence is already on the table in addition to this particular offense. Secondly, again, I'll also just raise again that it could very well target the very people it's purporting to protect. And so we're also concerned that it removes judges' ability to have discretion for really analyzing what's happening in cases, case by case, and really understanding how the facts line up to the sentence determination. And so it does not safeguard against a judge's role of neutrality. And so with all of those reasons, we think that, one, this bill does not actually help the issue that has been identified as a priority. But then, two, we have numerous opportunities to address the actual underlying issue of trauma, of poverty, of mental health, all those things are great. But sending people simply to just become incarcerated because they participate in street gang activity, one, does not make gang activity go away. Two, does not make our community safer. And three, it does not ultimately give us to the point of restorative justice, which makes communities whole. And so with that, Mr. Chairman, I'll stop. I don't want to reiterate points that have been made. And I thank you for consideration.
You have a question from Senator Rhett. Did you mean to push the button?
Oh, I'm sorry.
Okay. Any questions of the committee? All right. Thank you, Mr. Woodall.
Thank you.
Next, we have Brian Nunez with Southern Poverty Law Center. We have two others after you, just so everybody knows. Good evening.
Good afternoon, Chairman. Well, evening now. And members of the committee, my name is Brian Nunez, and I'm the Georgia Policy Associate for the Southern Poverty Law Center and SPLC Action Fund. We are dedicated to safeguarding the civil and human rights of all people. We know that you're all trying to address the serious issues in our states, and we understand that Georgians want to see positive changes that lead to less violence and a fair criminal legal system. We know that SB 44 is one of Governor Kemp's priorities, but we think that there might be some alternatives to creating new mandatory minimums in order to curb gang-related activity. Bills like SB 44, unfortunately, do very little to address the reasons why people may be compelled to engage in this kind of activity in the first place. Anytime you have mandatory minimums, you take away a judge's discretion, and even with the exceptions and caveats that are written in the bill, if a judge is facing an election, for example, he or she might not feel like they can go below a mandatory minimum sentence, even if it is the best decision for that particular case. We think that you will agree that Georgians deserve fair and impartial justice. Mandatory minimums can also incentivize district attorneys to overcharge in certain cases, which can lead to overcriminalization of certain communities, especially low-income communities and communities of color. In practice, we've seen that these sentence standards are not always tied to the severity of the conduct, but nevertheless, they will continue to fuel mass incarceration. As it has been previously stated, Georgia already has severe penalties and punishment for gang activities, some of actually the strictest and harshest in the nation. We're not sure that this tactic is working, and we don't need to add to our criminal code to address this issue. Lengthy and costly mandatory minimum sentences do not appear to reduce crimes, as we've seen. What they do instead is impose a high economic and social cost on Georgians as taxpayers and on the families of those impacted. The best way to make communities safer is by investing in them. Evidence-based studies show that community mobilization and social interventions are far more effective than harsher punishments in reducing gang-related activity. And we're happy to provide you with some of these studies and share some of the ways in which we think we can invest in communities to reduce crime through employment programs, housing support, and other early interventions that would truly reduce crime and not just feed Georgia's mass incarceration system. Thank you.
All right, any questions for Mr. Nunez? All right, thank you.
Thank you.
Next, we have Ben Lind from ACLU of Georgia. Good evening.
Thank you, Mr. Chairman. Members of the committee, my name is Ben Lind, and I am a policy counsel with the ACLU of Georgia, the civil rights organization fighting for the civil rights and liberties of all Georgians. I just wanted to say, I guess I'm batting cleanup here, so that I agree with many of the points that have already been made. They've said the bulk of what I wanted to say today. However, I just wanted to bring a couple things to the committee's attention, just as this is something that we've been concerned about with the growing criminalization of individuals' expressive conduct and free association, which is generally protected under the First Amendment. So we have been reviewing more and more of these gang indictments as they've come out across the state. I'm holding one from Barrow County here. That is voluminous. And just wanted to bring a couple of varieties to the types of conduct that's not otherwise criminal, but be included as alleged as in furtherance of a conspiracy. And it's our concern that these are types of conduct that are now going to be subject to a 5-year mandatory minimum sentence, which is receiving text messages or registering an LLC or sharing social media content or appearing in photographs. I wanted to flag these because as a former prosecutor, I understand the necessity of telling a story through charging documents, but these types of overt acts so divorced from the actual alleged criminal conduct that underpins the criminal gang investigations are wholly inappropriate for mandatory minimum sentencing. The gang statute by its nature is designed to capture a wide variety of conduct, and with it capturing such a wide variety of conduct, I feel it's absolutely necessary that there is individualized sentencing so we can avoid disproportionate outcomes. So like I said, I know that most of that's already been said today, but just wanted to offer that perspective, and I'm happy to answer any questions.
All right, any questions, Mr. Lund? All right.
Thank you very much.
And last on the list is Jack Winnie, the Deputy Chief Assistant District Attorney from the Coweta Circuit. Hey.
Mr. Chairman, how you doing?
Good. About you?
Good, thanks.
Good.
I appreciate members of the committee too. Y'all give me the opportunity, and I know the hour's getting late, and y'all have heard from everyone already. And so I'll try to be brief, and I'd like to offer y'all the opportunity to, if I can answer any questions that may have come up in what the witnesses have said since Senator Hatchett presented the bill. So I would echo everything that Senator Hatchett said and everything that the governor and lieutenant governor and attorney general said about the current state of the gang crisis in our state. I am the deputy chief assistant DA for gang crimes in the Coweta Circuit. That's the judicial circuit just southwest of here. That's Coweta County, Carroll, Meriwether, Troup, and Heard counties. And I've been doing gang prosecution for going on about 7 years now. Pete Scandalakis, who's in the room back there, hired me in 2016, and I work for Herb Cranford, the DA, now. One thing that occurred to me to say, so we have, between 2017 and 2021, we prosecuted more cases than any other circuit in which a defendant was sent to the Department of Corrections on a Street Gang Act violation conviction. And we don't track the numbers. I know that there are agencies that do. I can say anecdotally, incarcerating gang members does reduce violent gang crime. And I think Senator Watson touched on this, and so did Senator Cowser. A lot of this with the reality of the situation is a lot of this is about incapacitation. The way that these gangs operate and indoctrinate and corrupt their members, they have to be removed from the community so as not to victimize other victims, would-be victims in the community. And one thing that I think is worth emphasizing with this bill in particular, I think it's going to save the lives of Georgians that would be victims of gang crime, but I think it also is going to save lives of would-be gang members, because something that we see on a daily basis, and y'all have heard from witnesses today already, I'm sure you've heard from others, is when gang members, higher-ranking gang members who have already been corrupted by the gang and its tenants, recruit these younger members. These gangs, by their nature, if they're a criminal street gang, exist to commit criminal gang activity. And one thing they do is encourage their youngest members, for a variety of reasons, most of which have been talked about already today, to perpetrate these crimes. And if we do incapacitate those who prey on juveniles, and I do think there would be a deterrent effect. I can't sit here and tell you, quantify that. Then there are these juveniles who will eventually become older too, who won't have thrown their life away by starting a life of gang activity, hurting other people through serious violent crimes, or they themselves getting killed in gang violence. So we support this bill and appreciate y'all's favorable consideration. And like I said, I'm happy to take any questions that anyone might have.
All right, you have a question from Senator Parent.
Thank you, Mr. Chairman. Thanks for being with us. Just listening to all the testimony and thinking about, what I know, the relatively small amount I know about mandatory minimums, gang activity, and my longevity in the General Assembly, which at this point includes having been here when we undertook, when I think we had the highest incarceration rate in the country, and sort of undertook recognizing that had not had the policy aims that undergirded the idea of locking them up and throwing away the key, right? And sort of undertook rolling that back, and I've watched as we have now gone in the opposite direction. So a couple questions for you. You know, I'm interested in this statistic that we still, despite some of the reforms from a number of years ago, have an extremely high incarceration rate. I believe the statistic was, if we were a country, we'd be fourth in the world. I know we already have tough gang laws. So given those facts, why aren't those working? Why and why would we think that making them harsher would?
So can you say that, given that we have the fourth highest per capita
incarceration rate in the world is the statistic that we heard.
Sure. So that, I know I said I could answer any question. That one's probably a little bit above my pay grade. One thing I can say is in my experience that, you know, when law enforcement identifies the bad actors in communities who are perpetrating gang activity in these communities, and when those gang members are removed by incarceration, they can't commit crimes in the community anymore. I mean, I know that doesn't answer your question. I'm not sure that I can, though.
Yeah, I mean, I do believe that we had the highest incarceration rate in the country back when Governor Deal started some of the criminal justice reform in 2011, 2012. I know that we aren't low now. So I guess looking at that landscape, it just causes a rational mind to say, well, if that hasn't worked, why do we go down the same road over and over? And what I hear you saying is basically that the public policy goal would be to cast a very wide net and to capacitate as many people as possible until they essentially age out of criminal activity. That's kind of what I'm hearing you say.
I wouldn't say cast a wide net or incarcerate as many people. I think the defendants who you know, the state can prove beyond a reasonable doubt participated in criminal gang activity, you know, are members or associated with a criminal street gang, have committed enumerated acts in furtherance of the gang's purposes or with another specific intent. I mean, obviously all sentencing is within the prerogative of this body. You know, I can say personally that I think it's good policy, but I know reasonable minds disagree. We've heard from folks today. But what I can say is I believe that incarcerating the people that are committing these crimes in our communities will make those communities safer.
Do you disagree with the ability to, you know, charge up to 40 years now on, I guess I thought we already have pretty harsh laws that already are not seeming to work. So I'm having trouble connecting all the dots here. Thank you for elaborating.
So I heard the hypothetical earlier where I think it was like a theft and a gang charge and a RICO would be 40 years. I think that would be 45 years theoretically, although, you know, it's not that simple because, you know, while theft can be criminal gang activity, it's not necessarily for one. So if you have a theft, to have a gang charge on the theft, a 1615-4A violation, there would have to be proof beyond a reasonable doubt that whatever that theft was committed in furtherance of a criminal street gang. You couldn't have a RICO based on a single theft, so I don't know how that would work, but I'm not sure I understand beyond that.
Well, just that from everything I know, we've already made our penalties pretty harsh, and if a prosecutor wanted to lock one up for a long time, I'm unaware that that's not possible, and moreover, it hasn't seemed to work. So But thank you so
Sure,
much
I
for
understand.
elaborating on all of it for me. I appreciate it.
Senator Setzler.
Appreciate your being here. I think this is a very serious problem we need to deal with as a state. What I wrestle with is just the practical application of things, and and I also wrestle with, and I've had constituents over the years that we pass a law that addresses an issue that's a real issue, but on the sort of the boundary, on the edges of the fact pattern, what they've done meets that threshold of getting them into, whether it's armed robbery, whatever it is. I've had people who were opioid addicts who walked into a CVS pharmacy and gave them a note saying, "I've got a gun, give me drugs," and that's not the picture most people have of an armed robbery. They
Right.
think of So as we think about this and we talk about the lower edge, if you will, the lower threshold of the fact pattern of recruiting for a criminal street gang, that's usually where my concern is if we've got a mandatory minimum sentence and the threshold that it takes to, quote, through actions of another such person's direction, cause, encourage another person to become a member of a street gang. What's the threshold that you got to prove in this subsection E? What threshold to become a member? Is it an act that you make to try to make that happen, or does the person actually have to join the gang? You have to have some demonstration that this person they recruited joined the gang and has done things in furtherance of the gang after you've, and so on.
Sure. So there are a couple ways of proving a subsection E violation currently, and this wouldn't really substantially change that. It's either causing, encouraging, soliciting, recruiting to, one, become a member or associate of a criminal street gang, two, participate in a criminal street gang, or three, conduct or participate in criminal gang activity. The third and final, I think, would be causing, encouraging, soliciting, so forth, another person to commit a gang-motivated crime, like a specific gang-motivated crime. That's conduct or participate in criminal gang activity is the same language as is in 1615-4A, where there's the nexus requirement. The other two ways of violating 1615-4E, recruiting, causing to become a member or associate, or to participate in the criminal street gang, there's not case law right now on what that threshold is. Now, one thing I can say is because of First Amendment arguments and concerns, that it will be construed to require, to be constitutional and require knowledge of the criminal enterprise, the criminal street gang. But the state of the law right now, there's not case law directly answering your question.
Okay. So, Mr. Chairman, if I could. So that's really what I'm wrestling with, is if some kid in a high school or middle school talks to another kid about their gang, hey, here's what I'm involved in, here's what I'm doing, you want to come to hang out with us somewhere. That's clearly an effort to further their involvement to ultimately join the street gang. But to trigger E, does it have to be I'm doing it not only with knowledge that it's going to be part of your goal is to have them become part of the gang? Is there an element in which you're recruiting them to commit a crime, which is that predicate offense? Does
Right.
it require recruiting for a predicate offense in the RICO statute?
So I think necessarily there would have to be knowledge. So first, let me back up. First of all, you're always going to have to prove that the gang is a criminal street gang, which is association, in fact, with common identifiers engaged in offenses enumerated as criminal gang activity. And our Supreme Court has said that at a minimum there must be proof that plans for the being engaged in criminal gang activity must be ongoing at the time. So it can't be it must be an illicit, it must be a criminal street gang and not just a gang that they're being recruited into. I think necessarily, based and partly based on the way that some of these arguments were addressed by our Supreme Court back when 1615-4A was being challenged. I think necessarily there will have to be proof of knowledge of the gang's criminal purposes, and although E doesn't necessarily require in when charged that way, commission of a particular act of criminal gang activity. I think there would have to be some sort of knowledge and intent to participate in the gang, which would be more than just, just saying they're joining. There must be some way that they are participating in the gang's criminal purposes because it's a criminal street gang.
Yeah. And Mr. Chair, I just asked the question because, I mean, if we are broadening this in lines 15 and 16, and again, I'm very friendly to the overall goal of this bill. I'm just trying to make sure we know, as you said, Mr. Chairman, understand what we're doing. Indirectly acting through another person to encourage somebody to become a member of a gang, I just want to understand what's included and what's not included in that. And if it's, I think we have to assume a way. I think we're talking about actors who are part of a gang that clearly exists. I don't think there's any doubt that we're talking about street gangs. I'm not talking about something that's a group of, thuggish friends. I'm talking about a real street gang, and someone's trying to effectuate that. I just want to make sure we're clear on what behaviors trigger a 5-year mandatory minimum. And if it's a, hey, go out and get other members to join you, if you get a gang sort of a supervisor person that talks to their middle schoolers and high schoolers, hey, go get people to go join the gang. Just trying to unpack what's going to automatically, so he gets a 5-year minimum. The people who are talking to kids in their classroom, does that trigger the minimum, or does it have to be in furtherance of, hey, tomorrow we're going to go rob this car, tomorrow we're going to go beat this kid with a pipe, tomorrow we're going to go vandalize property? Does there have to be that criminal element to trigger this, or is just recruiting activity? And you mentioned First Amendment speech. I'm just wrestling with that threshold.
Right, I understand, and so I would just, if I could, say a couple things. I mean, number one is and I'm not familiar with the origin of that language in 15 and 16, but the operative part of that charging provision has been on the books for some time, and like I said, I think necessarily, and it seems we agree that when this is construed, there will be a requirement of criminal intent with whichever way you violate it. Even if it's not it's easy when it's the third way of violating it, right? When it's causing another to conduct or participate in criminal gang activity. But I understand what you're saying. I hope that helped some.
Yeah, it's the recruiting somebody to join a gang to perpetrate a breaking and entering. I mean, the recruitment efforts, a 5-year mandatory minimum for underlying crimes and maybe lower level crimes. I just want to make sure we're on solid ground in doing it.
Senator Jones.
Thank you, Mr. Chair. I just have one question. In Georgia, do we have a statistical problem, not anecdotal, but a statistical problem, that in circuits in Georgia, where persons are found to be gang members and they've committed some type of overt act, they're a real gang member, that our judges are basically given probation 30-40% of the time? I mean, do we know what that is? Does any database exist to show this?
I don't know the answer to that.
All right, those are all the questions. Thank you.
Thank you, Mr. Chairman.
Senator Hatchett, you have any final remarks? I'll let you close this out. Either way.
Thank you, Mr. Chairman, members of the committee, and those that testified. I need to make one thing clear, because this is actually something that we brought up at length in several meetings. A child that recruits another child into gang will not be exposed to these mandatory minimums. If you're under the age of 17, you're a 16-year-old, you recruit a 14-year-old, unless a 7 deadly is associated, you're not going to be subject to the mandatory minimums. You'll be adjudicated through the juvenile process. Number two, the heart of this bill, and something that was brought to my attention, is across the state there are children as young as 13 that have committed murder. And I ask several of the DAs, the ADAs across the state, in your experience, those that have been charged with murder that are 13-year-olds, how many of them are not associated with the gang? And it's zero. Zero. So that is why this is so important. That is why these mandatory minimums need to stick. And that's why I'm asking for favorable consideration. Thank you.
All right, thank you. Senator, who pushed the button? Senator Hodges?
Yes, I pushed the button just to make a motion.
All right, now's the time.
Okay. Mr. Chairman, I move a due pass, or make a due pass motion on Senate Bill 44, version LC 480816-EC.
All right, Senator Hodges has moved to pass. We have a second by Senator Calzert. Any discussion? All right, all those in favor of the motion, please raise your hand. 1, 2, 6. Did I count right? 7, 6, 6. All opposed? 3. The motion carries.
Thank you, Mr. Chairman.
Thank you. All right, that's all the business we have today. With that, we're adjourned. Thank you.